All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience à la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good afternoon. Will the court officer please call the case?
Thank you. Good afternoon, Your Honors. Situation in the Central African Republic in the case of the prosecutor versus Jean-Pierre Bemba Gombo, case number ICC 01050108. For the record, Your Honor, we are in open session.
Thank you. My name is Christine van den Wijngaard. I am the presiding judge in the appeals arising from the case of the prosecutor versus Jean-Pierre Bemba Gombo. My fellow judges in this appeal are Judge Chile Eboyosuji, Judge Morrison, Judge Sanji Mnemasono Monageng, and Judge Piotr Hofmansky. May I ask the parties and participants to introduce themselves for the record, starting with the defense.
Good afternoon, Your Honour. Counsel for Mr. Bemba today are myself, Peter Haynes, Kate Gibson, and Mike Newton. We are assisted by our case manager, Cecile Lecole.
Thank you. The prosecution?
Thank you. Your Honours, my name is James Stewart. I'm the Deputy Prosecutor appearing for the prosecution this afternoon. And I have the honor to appear with Fabrizio Warilia, Director of the Prosecution Division, and Reinhold Gallmetzer, Marichel Rege, Matteo Costi, Matthew Cross, and Priya Narayanan, Counsel on Appeals.
Thank you. The legal representative of the victims, please.
Bonjour, Madame le Président.
Good afternoon, Your Honor. Good afternoon, Your Honors. My name is Marie-Edith Duzima, legal representative of victims in this case. I am assisted today by Evelyn Ombeni, our legal assistant in The Hague, Prisk Dipanga, and Lydia El Al, who are case managers. Thank you. Thank you very much, Madam.
The Chamber is delivering today its judgment in relation to the appeal of Mr. Jean-Pierre Bemba Gombo against the decision of Trial Chamber number 3 of the 21st of March 2016. This decision convicted him of war crimes and crimes against humanity. Our judgment of today is also in relation to the appeals of Mr. Bemba and the prosecutor against the sentencing decision of Trial Chamber 3 of 21 June 2016. This sentencing decision sentenced him to a joint sentence of 18 years imprisonment. I will hereafter refer to these decisions as the conviction decision and the sentencing decision. I shall first address the appeal against the conviction decision, starting with the procedural background. On the 21st of March 2016, the trial chamber convicted Mr. Bemba for the crimes against humanity of murder and rape, and for the war crimes of murder, rape, and pillaging, committed by troops of the Mouvement de Libération du Congo, the MLC, in the Central African Republic from on or about the 26th of October 2002 to the 15th of March 2003. The trial chamber found that Mr. Bemba, as a person effectively acting as a military commander and with effective control over the MLC troops, was criminally responsible for these crimes pursuant to Article 28, paragraph A of the statute. Mr. Bemba filed an appeal against the conviction decision on 4 April 2016 and filed his appeal brief on 19 September 2016. Mr. Bemba raises the following grounds of appeal. Ground 1, the trial was unfair. Ground 2, the conviction exceeded the charges. Ground 3, Mr. Bemba is not liable as a superior. Ground 4, the contextual elements were not established. Ground 5, the trial chamber erred in its approach to identification evidence. And ground 6, other procedural errors invalidated the conviction. The prosecutor filed her response to the appeal brief on the 21st of November 2016, and the victims filed their observations on the appeals brief on 17 January 2017. Mr. Bemba filed his reply and response to the appeal brief on the 23rd of January 2017, and his reply to the victims' observations on the 9th of February 2017. On 30 October 2017, the appeals chamber ordered the parties and participants to make submissions on the contextual elements of crimes against humanity. These were duly received between 30 November and 11 December 2017. From 9 to 11 January 2018, the appeals chamber held a hearing. During this hearing, the parties and participants made submissions and observations on the appeals concerning a number of specific questions that the appeals chamber had identified in its order of the 27th of November 2017. The parties and participants were thereafter invited to make further written submissions on the appeals by 19 January 2018. I will now give you an overview of the appeals chamber's decision. The judgment in the appeal concerning the conviction decision is issued by majority. Judge Eboyosuji, Judge Morrison, and myself form the majority. The majority has limited its assessment to ground 2 and a part of ground 3, as it is of the opinion that these issues are determinative of the appeal, and although we are not together on everything, we agree on the outcome. In addition, Judge Eboyosuji, Judge Morrison, and I will issue separate opinions on other aspects of the appeal. Judge Monaghan and Judge Hofmansky disagree with the reasoning of the majority and the outcome of the appeal, and they issue a joint dissenting opinion. At this juncture, I would like to highlight that while the appeals chamber has sought to reach a unanimous decision, it has not been able to do so. Judgments taken by majority are a common feature in many domestic and indeed international jurisdictions, where judges from different legal traditions come together to decide on often new and complex legal and factual issues. I will now address the standard of review. Looking at the trial chamber's factual findings, the majority assessed whether or not the trial chamber applied the standard of proof correctly. The appeals chamber must be satisfied that the factual findings that are made beyond reasonable doubt are clear and unassailable, both in terms of evidence and rationale. Accordingly, when the appeals chamber is able to identify findings that can reasonably be called into doubt, it must overturn them. Furthermore, the trial chamber must accompany its finding with reasoning of sufficient clarity. This reasoning must unambiguously demonstrate the evidentiary basis upon which the finding is based, as well as the trial chamber's analysis of this evidence. If the trial chamber fails to do so, the appeals chamber has no choice but to set aside the affected finding. It is also important that the duty of a convicted person to substantiate errors in the conviction decision should not lead to a reversal of the burden of proof. I shall now briefly summarize the views of the majority on ground 2 and the part of ground 3 that we consider to be determinative of the appeal. I shall then summarize the views of the minority judges on these grounds. Please note that the judgment and the attached opinions and not the present summary are authoritative. I will now address the second ground of appeal. Mr. Bemba's second ground of appeal relates to the scope of the charges against him. During the confirmation process, in the document containing the charges, the prosecutor listed a number of alleged criminal acts of murder, rape, and pillaging. However, through the use of expressions such as include or include but are not limited to, the prosecutor indicated that this list was not exhaustive. The pretrial chamber then confirmed the charges in broad terms. Subsequently, the prosecutor provided information on individual criminal acts which had not been expressly mentioned in the document containing the charges and the confirmation decision. The trial chamber convicted Mr. Bemba with respect to a number of such acts. On appeal, Mr. Bemba alleges that, quote, nearly 2/3 of the underlying acts for which he was convicted were not included or improperly included in the amended document containing the charges and fall outside the scope of the charges, unquote. He asserts that the trial chamber erred in law by relying on these acts for the conviction. The appeals chamber notes that the conviction decision makes no reference to even an approximate number of the individual criminal acts of murder, rape, and pillage that the trial chamber found established. Nor does it make any further demarcation of the scope of the conviction. The conviction would therefore appear to cover potentially all such crimes committed by MLC soldiers in a territory of more than 6,000 square kilometers and over a period of more than 4.5 months. The majority of the appeals chamber considers that the conviction decision must be understood as convicting Mr. Bemba for the specific criminal acts of murder, rape, and pillage that the trial chamber found to be established beyond a reasonable doubt, and which were recalled in the concluding sections of the conviction decision in relation to each crime. The broad disposition in the conviction decision and the only slightly less broad conclusions of the trial chamber in relation to the crimes charged do not, in reality, reflect what Mr. Bemba was convicted for. Rather, they are summaries of the trial chamber's findings in relation to the criminal acts of murder, rape, and pillage that had been established beyond reasonable doubt. The conviction of Mr. Bemba, however, was entered in relation to these specific criminal acts only. I will now turn to the scope of the charges. Having determined the scope of the conviction, I will now address the scope of the charges. The appeals chamber, by majority, Judge Monageng and Judge Hofmansky dissenting, considers that both the formulation in the operative part of the confirmation decision, as well as in the relevant parts of the document containing the charges, are too broad to amount to a meaningful description of the charges in terms of Article 74, paragraph 2 of the statute. simply listing the categories of crimes with which a person is to be charged, or stating in broad general terms the temporal and geographical parameters is not sufficient to comply with the requirements of Regulation 52, paragraph B of the Regulations of the Court, and does not allow for a meaningful application of Article 74, paragraph 2 of the statute. However, the Appeals Chamber notes that both the amended document containing the charges and the confirmation decision contained more specific factual allegations as to the crimes for which Mr. Bemba was to be tried, namely in the form of the identified criminal acts. These were prominently mentioned in the operative part of the amended document containing the charges. They were also taken up as part of the evidential analysis in the confirmation decision. Thus, the facts and circumstances were described in relation to the crimes at the level of individual criminal acts. The Appeals Chamber considered by majority, Judge Monaghan and Judge Hofmansky dissenting, that the criminal acts that the prosecutor added after the confirmation decision by means of disclosure and inclusion in auxiliary documents cannot be said to have been part of the facts and circumstances described in the charges in terms of Article 74, paragraph 2 of the statute. This is because, as set out, the prosecutor had formulated the charges at the level of detail sufficient for the purposes of that provision only in respect of the criminal acts. For that reason, adding any additional criminal acts of murder, rape, and pillage would have required an amendment to the charges, according to Article 61, paragraph 9 of the statute. This, however, did not occur in the case of hand. The Appeals Chamber finds, by majority, that the criminal acts that were added after the confirmation decision had been issued and that were not listed in the amended document containing the charges did not form part of the facts and circumstances described in the charges, and Mr. Bemba could therefore not be convicted for them. The same applies to the criminal acts put forward by the victims. The Appeals Chamber therefore grants this ground of appeal and finds, by majority, Judge Monaghan and Judge Hofmansky dissenting, that the trial chamber erred when it convicted Mr. Bemba of such acts which did not fall within the facts and circumstances described in the charges in terms of Article 74, paragraph 2 of the statute. This means that the number of criminal acts of which Mr. Bemba was convicted was 1 murder, rapes of 20 persons, and 5 acts of pillaging. I am now turning to the third ground of appeal. Under the third ground of appeal, Mr. Bemba argues that the trial chamber erred in finding that he failed to take all the measures that were necessary and reasonable to prevent or repress the crimes committed by MLC forces or to submit the matter to the competent authorities. On this point, Mr. Bemba makes 5 submissions. 1. The trial chamber failed to apply the correct legal standard. 2. It misappreciated the limitations of the MLC's jurisdiction and competence to investigate. 3. It ignored that Mr. Bemba had asked the CAR Prime Minister to investigate the allegations. 4. It erred by taking into account irrelevant considerations. And 5. Its findings on the measures taken were unreasonable, misstated the evidence, and ignored relevant evidence. The appeals chamber, by majority, Judge Monageng and Judge Hofmanski dissenting, have identified serious errors in the trial chamber's assessment of whether Mr. Bemba took all necessary and reasonable measures to prevent, repress, or punish the commission of crimes by his subordinates. First, the appeals chamber finds that the trial chamber erred by failing to properly appreciate the limitations that Mr. Bemba faced in investigating and prosecuting crimes as a remote commander sending troops to a foreign country. Whilst the trial chamber had some regard to such difficulties, it ignored significant testimonial evidence indicating that Mr. Bemba's power to investigate crimes committed in the car was limited, and that he faced logistical difficulties in conducting investigations. It also ignored the fact that throughout the 2002-2003 car operation, the MLC relied upon cooperation with the car authorities. Second, the appeals chamber finds that the trial chamber erred by failing to address Mr. Bemba's argument that he sent a letter to the car authorities. While failing to address this argument, it nevertheless concluded that Mr. Bemba had not referred allegations of crimes to the car authorities for investigation. The trial chamber's finding that Mr. Bemba had not taken necessary and reasonable measures was in part based on a finding that Mr. Bemba had made no effort to refer allegations of crimes to the car authorities. The trial chamber was wrong to make this finding without expressly considering Mr. Bemba's argument that he did indeed do so. Third, the trial chamber erred in determining that the motivations that it attributed to Mr. Bemba precluded him from taking the required necessary and reasonable measures in good faith. However, the motive to preserve the reputation of troops does not intrinsically render the measures any less reasonable or necessary in preventing or repressing crime. Fourth, the trial chamber erred in faulting Mr. Bemba for the fact that the measures that he ordered were poorly executed or achieved limited results. It failed to appreciate that the measures taken by a commander cannot necessarily be faulted merely because of shortfalls in their execution. In this case, the trial chamber appeared to attribute to Mr. Bemba the alleged limited results of the independent inquiries simply because the inquiries were initiated by him. Fifth, the trial chamber erred in finding that Mr. Bemba failed to empower other MLC officials to fully and adequately investigate and prosecute crimes. It arrived at this conclusion in apparent contradiction to an early finding that other MLC commanders exercised some disciplinary authority in the field. Moreover, the trial chamber failed to explain what more Mr. Bemba should have done to empower the MLC officials to fully and adequately investigate and prosecute allegations of crimes, and how he fell short in that regard. Sixth, the trial chamber erred by basing its assessment of the necessary and reasonable measures on the totality of crimes allegedly committed by the MLC, whereas only a limited number of these crimes were proved beyond reasonable doubt. A finding that the measures deployed by a commander were insufficient to prevent or repress an extended crime wave does not mean that these measures were also insufficient to prevent or repress the limited number of specific crimes of which the commander is ultimately convicted. Seventh, the trial chamber erred by taking into account the redeployment of MLC troops as a measure available to Mr. Bemba. The appeals chamber considers it axiomatic that an accused person be informed promptly and in detail of the nature, cause, and content of a charge. However, in no document designed to give Mr. Bemba notice of the charges was the redeployment of troops to minimize contact with the civilian population specifically identified as a necessary and reasonable measure that Mr. Bemba should have taken. The deployment of troops was mentioned in the amended document containing the charges, but only in the context of establishing Mr. Bemba's effective control over the MLC forces. As a result of the lack of proper notice, Mr. Bemba suffered prejudice. The appeals chamber finds that these errors had a material impact on the trial chamber's finding that Mr. Bemba failed to take all necessary and reasonable measures. The appeals chamber thus finds, by majority, Judge Monaghan and Judge Hofmansky dissenting, that the trial chamber's conclusion that Mr. Bemba failed to take all necessary and reasonable measures in response to MLC crimes in the car was materially affected by errors. And Mr. Bemba cannot be held criminally responsible under Article 28 for the crimes committed by MLC troops during the car operation. I now come to the appropriate relief. In these circumstances, the appeals chamber, by majority, reverses the conviction of Mr. Bemba. It discontinues the proceedings with respect to those criminal acts in relation to which the trial chamber entered a conviction, even though they were outside the scope of the facts and circumstances of the case. In relation to the remaining criminal acts, it enters an acquittal because the errors found with respect to necessary and reasonable measures extinguish his responsibility in full. May I ask the registry to restore the calm in the courtroom? In the public gallery? May I ask the registry to restore the order in the public gallery, failing which we will have to adjourn?
Your Honor, we are working on it.
I am not finished with reading the judgment. Can you please sit down? Can you please sit down? May I ask you to sit down? I shall now proceed to summarize the reasons for Judge Monaghan and Judge Hofmansky's dissent from the majority decision. I will focus on the three main contentious issues, which are, first, the standard of review on appeal. Second, the question of whether Mr. Bemba failed to take all necessary and reasonable measures to prevent, repress, or punish the crimes. And third, the question of whether the conviction exceeded the scope of the charges. The dissenting judges address the other grounds of appeal in their dissenting opinion, which is the authoritative document. Based on their consideration of all arguments raised, they would have confirmed the impugned decision. I address first the standard of review. Regarding the standard of review on appeal, the dissenting judges disagree with the majority's view that the appeals chamber must overturn factual findings of the trial chamber if they can reasonably be called into doubt. They view this as a significant and unexplained departure from the conventional standard of review for factual errors applied to date by the appeals chamber of this court, as well as other international and internationalized courts and tribunals. The dissenting judges consider that it is not sufficient that there are serious doubts about the factual finding entered by the trial chamber. In case of doubt, they consider it necessary for the appeals chamber to review the evidence supporting the factual findings in question, to itself determine the issue or to remand the matter to a trial chamber for that purpose. Therefore, in assessing Mr. Bemba's ground of appeal, the dissenting judges have applied the conventional standard of appeal, which accords some deference to the trial chamber's findings of fact. I am now addressing ground 3, the necessary and reasonable measures. The dissenting judges consider that the application of this modified standard of review in practice has led the majority of the appeals chamber to an erroneous conclusion regarding Mr. Bemba's failure to take all necessary and reasonable measures to prevent, repress, or punish crimes committed by MLC troops. In the view of the dissenting judges, 3 core aspects of the trial chamber's reasoning supported the conclusion that Mr. Bemba failed to take all necessary and reasonable measures within his power to prevent or repress the commission of crimes or to refer the matter to the competent authority. First, the trial chamber acknowledged that Mr. Bemba took a few measures of the course of the 2002-2003 car operation, but found that they were all limited in mandate, execution, and/or results. Second, the trial chamber found that the MLC troops continued committing crimes throughout the 2002-2003 car operation, and that consistent information regarding these crimes was brought to Mr. Bemba's attention. Third, the trial chamber considered the limited and deficient measures Mr. Bemba had taken in light of his extensive material ability to prevent and repress the crimes. Based on this assessment, the trial chamber concluded that the measures taken patently fell short of all necessary and reasonable measures to prevent and repress the commission of crimes within his material ability, and that Mr. Bemba could not be said to have referred the matter to the competent authorities. As further explained in their dissenting opinion, the dissenting judges have reviewed the trial chamber's finding in light of the arguments raised by Mr. Bemba on appeal, and are unable to identify any error in the trial chamber's finding or any unreasonableness in the overall conclusion. The dissenting judges would therefore have rejected Mr. Bemba's arguments and confirmed the findings and conclusions of the trial chamber. The majority reaches an alternative conclusion based on an analysis that the dissenting judges are unable to accept and find to be deeply flawed for the reasons that I shall now summarize. Regarding the measures actually taken by Mr. Bemba, the majority identifies 3 errors in the trial chamber's analysis. First, it finds that the trial chamber paid insufficient attention to the fact that MLC troops were operating in a foreign country with the attendant difficulties on Mr. Bemba's ability to take measures. In the dissenting judge's view, the majority's conclusion that Mr. Bemba was limited in his ability to take measures in the Central African Republic is based on an uncritical acceptance of Mr. Bemba's arguments and an erroneous assessment of a fraction of the evidentiary record to which the trial chamber had regard. The dissenting judges find this approach to be untenable, especially in the circumstances where Mr. Bemba does not point to any attempts to investigate that were in fact made and proved impossible. They would have found that the trial chamber properly considered Mr. Bemba's ability to take measures based on the evidence in this case. The second error identified by the majority is that the trial chamber appears to have treated Mr. Bemba's motivations as determinative of the adequacy or otherwise of the measures he took. The dissenting judges consider that the majority's view of the trial chamber's reasoning does not accurately reflect the approach of the trial chamber and is not supported by any proper reading of the conviction decision. The dissenting judges consider inappropriate the majority's use of speculative language to impute reasoning to the trial chamber that is not apparent from the wording of the decision. The dissenting judges would not have found any error in the trial chamber's consideration of Mr. Bemba's motivations. The third error identified by the majority is that the trial chamber failed to establish that Mr. Bemba purposively limited the mandates of commissions and inquiries set up. The dissenting judges consider the majority's position to misconstrue the nature of criminal liability under Article 28 of the statute. In their view, this mode of responsibility, the issue is not whether Mr. Bemba was responsible for any deficiencies or limitations in the measures that he took. Rather, the question is whether, also in light of the measures that Mr. Bemba did take, it can said that he took all necessary and reasonable measures to prevent, repress, or punish the commission of crimes. The dissenting judges would have found that the trial chamber did not err in its consideration of the issue. Regarding the continuation of the crimes in spite of the measures taken, the dissenting judges note that the majority expressed doubt about the trial chamber's findings regarding the scale and duration of the crimes. Similarly, although it expresses concerns regarding the trial chamber's finding as to Mr. Bemba's effective control and knowledge of the crime, the majority does not resolve either of the question it raises. This, in the dissenting judge's view, has the unfortunate result that the issues essential to the determination of whether Mr. Bemba took all necessary and reasonable measures are left unresolved for the purposes of this appeal. The dissenting judges consider that the majority should have resolved any concerns regarding the trial chamber's findings based on its own review of the evidentiary record of the present case. In the absence of such a review and a positive determination of the issues, it is unclear to the dissenting judges how the majority could proceed to overturn the findings of the trial chamber and enter an acquittal. For their part, the dissenting judges have carried out a full review of the factual findings and evidence relied upon by the trial chamber and are satisfied that there was no error in the trial chamber's finding that many crimes to be committed throughout the 2002-2003 car operation, that Mr. Bemba knew of these crimes and that he had effective control over his troops. The dissenting judges consider that the majority's skewed consideration of this case is the result of the implementation of the modified standard of appellate review in practice. It led the majority to overturn the trial chamber's factual findings without engaging in any meaningful way with the factual findings entered by the trial chamber or demonstrating any awareness of the evidence on which these findings were based. The dissenting judges consider it unsurprising that the majority had doubts about the trial chamber's factual findings and overall conclusion, given its limited assessment of the evidence. The dissenting judges reiterate their view that doubts are not a sufficient basis to reverse factual findings of the trial chamber, in particular in the absence of consideration of all relevant evidence. What is required is a determination of whether a reasonable trier of fact could have reached the findings in question based on the evidence that was before the trial chamber. For the dissenting judges, the key question, both during the trial and on appeal, is whether measures that Mr. Bemba took were commensurate with all the necessary and reasonable measures that were within his power. The inquiry in the present case was twofold: whether Mr. Bemba failed to take all necessary and reasonable measures with his power to 1. Prevent or repress the commission of crime, 2. Submit the matter to the competent authorities for investigation or prosecution. The dissenting judges consider that these questions could only be properly answered with due regard to the scale and duration of the crimes committed, Mr. Bemba's knowledge thereof, and the full range of measures available to him in the circumstances, based on the extent of his control over the troops. The dissenting judges regret that the majority limited its analysis to the measures that Mr. Bemba took, and they considered that its confined examination of an isolated aspect of the case led it to an erroneous conclusion. For all these reasons, the dissenting judges would have confirmed the trial chamber's finding that Mr. Bemba failed to take all necessary and reasonable measures. I shall now turn to the dissenting judges' view on the second ground of appeal concerning the scope of the charges. The dissenting judges regret that they are unable to agree with the majority's conclusion that some of the criminal acts that the trial chamber found established beyond reasonable doubt were outside the scope of the charges. In the view of the dissenting judges, the prosecutor's case against Mr. Bemba was brought by geographical, temporal, and other substantive parameters. The pre-trial confirmed the charges as such. The trial chamber, therefore, could consider any criminal acts that fell within these parameters, subject to the requirement of proper notice to the accused. This conclusion of the dissenting judges is based on the following consideration. The dissenting judges consider that the statute vests the prosecutor with the power to formulate the charges and to set the factual parameters of the case. In their view, Article 74, paragraph 2 of the statute ensures that the trial chamber does not exceed the factual scope of the case brought by the prosecutor. Its purpose is to delineate the jurisdiction of the trial chamber. The dissenting judges consider that the prosecutor may set broad parameters for the charges depending on the circumstances of the case she intends to bring. For instance, in the case of mass crimes that the accused did not directly participate in, the prosecutor may decide to describe the crimes alleged broadly for the purposes of limiting the trial chamber's jurisdiction under Article 74, paragraph 2 of the statute. Regarding the pre-trial chamber's role, the dissenting judges concerned that its aim is to determine whether there is a case to be tried and not to engage in a lengthy fact-finding process to a lower standard of proof. Where specific criminal acts are alleged to support a more broadly described charge, they are primarily vehicles to prove a broader charge, and the pre-trial chamber must consider these acts only insofar as it may serve its inquiry into whether the person committed the crimes charged. The pre-trial chamber does not confirm or crystallize all factual allegations for the purposes of the trial. Therefore, according to the dissenting judges, if the prosecutor formulates the charges broadly, this means that additional individual criminal acts may be alleged for the purposes of the trial, provided that they fall within the scope of the crimes confirmed and provided that the accused's right to notice and time for the preparation of his or her defense are respected. The dissenting judges are of the view that the charges in the present case were formulated broadly by way of temporal, geographical, and other factual parameters. These charges encompassed acts of murder, rape, and pillaging committed by the MLC troop in the car from on or about 26 October 2002 to 15 March 2003. They were not limited to the specific individual criminal acts mentioned in the document containing the charges and in the confirmation decision. The dissenting judges consider this description of the facts and circumstances described in the charges to be adequate from the perspective of Article 74, paragraph 2 of the statute in the circumstances of this case. For these reasons, the dissenting judges would have found that Mr. Bemba's conviction did not exceed the facts and circumstances described in the charges that were brought against him. The dissenting judges would therefore have concluded that Mr. Bemba failed to show that the trial chamber committed a legal error and would have rejected the second ground of appeal. Consequently, the dissenting judges would not have discontinued the proceedings with respect to the criminal acts which the majority finds to exceed the facts and circumstances described in the charges. I now turn to the appeals against the sentence. As a result of this judgment on Mr. Bemba's appeal, the appeals chamber unanimously considers the appeals lodged by Mr. Bemba and the prosecutor against the sentencing decision to be moot and dismisses them as such. This concludes the summary of judgments in this case. The appeals chamber notes that in the case of an acquittal, the acquitted person is to be released from detention immediately. However, Mr. Bemba was convicted by this court in another case of offenses against the administration of justice, and his sentence in relation to this conviction is still currently before Trial Chamber 7. Thus, while the appeals chamber finds that there is no reason to continue Mr. Bemba's detention on the basis of the present case, it rests with Trial Chamber 7 to decide, as a matter of urgency, whether Mr. Bemba's continued detention in relation to the case pending before that chamber is warranted. Therefore, Mr. Bemba will not be released immediately. I wish now to thank the interpreters, the court reporters, the technical supporting staff, the security, the legal officers of chamber and other staff of chambers, the parties and participants in the proceedings. The hearing is now adjourned.
All rise.